The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. This is Christy and Yanaya from TechServe Alliance. Welcome to the certification webinar series. Today's webinar is Critical Legal Knowledge Points. There will be a question and answer session after the presentation, so feel free to write in any questions you would like to have answered in the question box on the right side of your screen. Also, we are recording today's presentation and it will be available to TechServe members on the e-learning center of the website. I'd like to introduce our speaker for the day, Barb Bruno, president of Good as Gold Training. Barb?
Thanks so much. I'm so pleased to be with all of you today. And today we're going to discuss a very important topic, which are critical legal knowledge points. This training is basically going to emphasize some of the critical knowledge points that are contained in the legal and compliance section of the CPSAE and CPSR training materials. Now, obviously, there's much more detail in the certification study guide, and these materials were written by Craig Etter and Mark Roberts. Now, I want to basically review the lessons that are contained in the certification program, because most certification programs, just to give you sort of an overview, are 100% legal. What TechServe Alliance decided to do was make the program 1/3 legal and 2/3 practical application for both the recruiter, account executive, owners, and managers. And the reason for that is they wanted this program to really give a base of knowledge that would equate to increased sales and profits and increase, basically income for the people that are certified. We wanted to make them more successful. But obviously, knowing the laws is critical. And so the 10 areas that the program currently covers is the Equal Employment Opportunity Laws, hiring and termination obligations. Number 3 is immigration laws. Number 4, overtime laws. Number 5, Family and Medical Leave Act. Number 6, workmen's compensation laws. Number 7, employment taxes. Number 8, co-employment. We wanted to define that. Number 9 is client restrictions on the length of staffing assignments and what are the implications of the Microsoft case and leased employee rules. And lastly, commercial law and contracts. Now, you might be looking at this going, where is information on the Health Care Reform Act? That is going to be added to the exam this fall. When we actually designed the certification program, it was before a lot of the details were actually known and sort of the jury was still out on where things were going to land. And so currently, that is not in the certification program, but it will be in the near future. I want to start out with the Civil Rights Act, which really prohibits discrimination in hiring, compensation, promotion, termination, and other terms and conditions of employment based on the employee's race, color, religion, sex, or national origin. And those are the words that you must know. You cannot discriminate against the last words that I mentioned, which are race, color, religion, sex, or national origin. The Civil Rights Act basically defines an employer as an organization that must be in an industry affecting commerce and have 15 or more employees for each working day in each of 20 or more calendar weeks in the current or preceding calendar year, and any agent of the organization. And I've actually had some owners say, well, I don't employ 15 people. I don't have 15 contractors out there. And we most certainly don't have 15 people in our office. Well, while the term employee is broadly interpreted, properly classified independent contractors are not covered by the Act, nor are they counted in determining the 15 employee threshold. However, because you are placing people in companies that employ more than 15 people, you are covered by the laws, by all of the employment laws. And it's basically because, we are working within companies that do have more than 15 employees. Unlawful to fail or refuse to refer for employment or to classify or refer for employment or otherwise discriminated against any individuals because, again, of their race, color, religion, sex, or national origin. And you will see those words mentioned over and over again, not only in the Civil Rights Act, but in other laws. And that was more or less the broad spectrum that was covered. Now, obviously, many new things have been introduced by other subsequent laws we're going to discuss. But it's important for all of you to know these laws, and let me explain why. as an owner, an owner of a staffing firm, a contract firm, a search firm is responsible for every action that anyone takes that works for them. So it's not enough just for the owner to know the employment laws. You're interacting with clients. You're interacting with candidates on a daily, weekly, monthly basis. And that's why you have to be very informed of all the new laws. And this, basically is your responsibility, because if, in fact, you do something illegal, your employer could be held liable, you could be held liable, and so could your company. And so that's why it's so important. I know often, recruiters don't want to be bothered with learning the laws, but it's a critical part of your job. Sexual harassment also comes under the Civil Rights Act and can fall into one of two categories, either quid pro quo harassment, and that's a threat or promise related to employment in return for a sexual favor, or a hostile work environment. The Pregnancy Discrimination Act of 1978 prohibits discrimination on the basis of actual or expected pregnancy. Pregnant women capable of performing the work must be referred and considered for employment. Now let's talk about circumstances under which a staffing firm may be found liable. If you honor a client's request to discriminate against individuals in a protective class for a position not qualifying for a BFOQ, a bona fide occupational qualification. And I do want to explain what a BFOQ is. If there is a job where someone has to lift 500 pounds, that's part of the job. So you need somebody who's very physically able to be able to lift that much. Or say in the case of, let's use a really funny example. Say that somebody is applying for a bathing suit modeling position, and it's a female bathing suit. Well, the BFOQ could be that only people of the female gender can apply for the job. If a catalog is hiring children's models for a children's catalog, obviously a BFOQ is only children can apply. So a BFOQ has to be something that that basically goes for every single person that's ever had this position. This bona fide occupational qualification was in place. And you might say, well, they say you can't discriminate against sex, but if the job, if only a woman can fit in the job, that's a bona fide occupational qualification. But many clients, and sometimes clients think that they can use us to discriminate. And absolutely, positively, that is not the case. And if they do quote a bona fide occupational qualification, you have to make sure that everybody that they've hired for that particular position, that this BFOQ was applied, not just for a particular hire that they're working with you on. Also, retaliation for termination of an employee for filing a charge of discrimination against a staffing firm or its client. If you have one of your contractors and they file a charge of discrimination, and as a result, they're terminated, they no longer work for you, that's where you can be found liable. And again, these are all things that you must be very aware of. Let's talk about joint liability. If a client refuses to accept a staffing firm's employee who is a member of a protected class, or both the staffing firm and the client may be liable for discrimination or harassment by an employee of a staffing firm against another employee at the client site, and parties fail to take immediate and appropriate action. And that's why the lines of communication have to stay completely open once you've got a contractor on the job. It's not like you place a contractor on the job. And when you think of the duration of some of these contracts, I mean, they can go into years. You have to make sure that you're in touch with your contractors, and if there is any problem, anything relating to discrimination, that you take immediate and appropriate action. Let's talk next about the Age Discrimination and Employment Act. And this was basically, ADEA is what it's referred to, and this was passed in 1967. Now, the Age Discrimination Act, or ADEA, prohibits an employer from discriminating on the basis of age against an employee who is 40 years of age or older. Now, you may think that, wait a minute, what about people that are under 40? People under 40 are not protected by the Age Discrimination Act. It strictly protects people that are 40 and above. Liable firms must meet a 20-employee threshold. Of course, we're representing firms that employ more than 20 employees. So like I stated earlier, all these laws apply to your company. Whether you're a small boutique firm or you're a very large firm with hundreds of contractors out there, these laws affect all of us. Now, protections are limited to individuals 40 years and older, although age can be permissible criterion for a BFOQ. So if you're thinking of, like the example I gave before, if people are hiring for a children's catalog and they need children's models, well, obviously they can say we need children between the age of 3 and 5, or 5 and 10. They can be very specific on the age because, again, this absolutely affects the exact type of person they need for their catalog, so that's not considered discriminatory. Let's talk about the American with Disabilities Act of 1990. Under this act, it's unlawful for an employer to discriminate on the basis of disability. Liable firms must meet a 15-employee threshold. ADEA makes it unlawful to discriminate against a qualified individual with a disability in regard to a job application procedure, hiring, advancement, or termination, compensation, job training, and other terms, conditions, and privileges of employment. Discrimination based on disability is permitted if it is consistent with business necessity, and such performance cannot be accomplished by reasonable accommodation. If you need somebody to do proofreading, you can't necessarily hire someone who's blind. If you're hiring somebody that hearing is a big part of their job, if somebody is hearing impaired and there's no reasonable accommodation for them, or if there's physical, say that a job requires somebody to stand up and the person that applies for the job is confined to a wheelchair. It could be an assembly line, it could be some type of position that involves a person to stand up. Then obviously those, that disability would prevent them from performance of the job, and you couldn't accomplish that by reasonable accommodation. If somebody can't stand up and the job involves standing up, there's nothing the employer can really do. So discrimination is permitted in that particular situation. A qualified individual also means a person with a disability who, with or without reasonable accommodation, can perform the essential functions of a position. And so if somebody applies for a job and they're disabled, but they do not have the skills, the experience needed for the job, or they don't have the certifications or the education that the job asks for, they do not have to be hired just because they're disabled. I mean, they have to be a qualified person, which means that regardless of their disability, if they were not disabled, they have the capability, they have the experience, the education, the skill sets, to do a position. So there is that phrase, qualified individual. Qualifying disability refers to any physical or mental impairment that substantially limits one or more of the major life activities of such individuals. So this refers to both physical as well as mental impairment, and that's important for you to know. And employers can only ask disability-related questions or require medical examinations after making an offer of employment and before the employment begins. So these are not questions that an employer can ask prior to making an offer of employment, to a candidate. Let's talk about the interview and selection problem, because there are key areas covered by fair hiring and anti-discrimination laws. And that's why it's so important for all of you listening to my voice. You have to understand that we live in the age of YouTube and cell phones and videos and recordings. And I can tell you from personal experience, I'm getting calls from employers and from owners of contract staffing firms saying, my God, we had a candidate film and videotape our receptionist. We had a candidate that, they sent in 3 different candidates. One was a minority, one was not. One could barely speak English. And they taped our interviews, and now we have a lawsuit because they're saying we didn't ask the exact questions of every candidate that we were interviewing. Now, you and I both know you're not going to do a full interview if you realize somebody does not have the skill sets and you're going to do a courtesy interview. But whether you're doing that interview in your office, using Skype, if you're doing a phone interview, you never know when you're being recorded. And you never know when those recordings are going to go public. Or you never know if somebody is trying to set you up to see if your organization discriminates through the interviewing process or the selection process. And we're a very big target right now. You are in the best profession at the best time in history. Our business has never been better. There's more of a need for what you do than there's ever been in the history of our profession, which is the good news. But it's almost like you have a target on your back. And you have to realize that there's areas that are covered by the fair hiring and anti-discrimination laws that really prohibit what you can ask during interviews. And so what I want to say to all of you is, you have to have a structured interviewing form. You have to have a way that you're, asking the same questions of every candidate. You can't ask one candidate one set of questions and another candidate another set of questions without the possibility of a discrimination lawsuit and without the possibility of you breaking a law. And you might say, well, I basically, recruited this developer, so all I'm going to do is talk to the developer about, what we have to offer. I'm telling you that to protect yourself, you have to conduct a general interview, finding out what's most important to each candidate, asking the same specific questions of every candidate. You have to have an interviewing guide that everybody in your company follows. You have to know what your front desk person is saying on the phone when people are calling in, because you could have 2 or 3 different types of people calling. You could have somebody call in that sounds very old and not able to function much, but guess what? They're in that age-protected, grouping. And so all I'm saying is you have to be more aware now than you've ever been before, because you never know when you're being recorded. And I want you all to think about the interviews you've just done this week. Did you follow the same structured interview in every candidate that you interviewed? Or if I was interviewed by you, would I have had a different interview than somebody else? And if I'm protected, under some of these laws, could I file a discrimination suit against you? Because I feel that you didn't ask me the questions that you asked a male that came in that had similar experience to me. So these laws are more important than ever because we live in the age of video and Instagram, and you never know when a person is taping you. I'll give you an example. I had somebody on the phone yesterday that called me basically asking me, a question about staffing and recruiting firms. And it was a publication that had called me, and they were asking me to give an opinion. And I gave my opinion, and after I gave my opinion, they said, oh, we wanted to inform you that we recorded everything you said. Now, I know enough to know that whenever anybody calls me from a publication or I know something is going to end up in print, I'm very careful of what I say because I do represent our profession. But, again, the same thing could happen to you. And sometimes you don't even know you're being recorded. So think about your interview. These are all the areas that are covered: age, criminal record, national origin, culture, language, disability, race, color, religion, sex, alcohol or drug use, affiliations, marital or family status. And a lot of people get caught on the last one, marital or family status, when you start asking questions about daycare, or, can you work long hours? Whatever questions you're going to ask, you need to ask everybody to protect yourself, protect your owner, and protect your business. Information offered by the candidate in an interview that is protected should not be pursued, placed in interviewing notes, or used as part of the decision-making process. You and I both know that sometimes candidates just say things that we're like, I can't believe they just said that, because it's not a question you could have ever asked them. And you might think to yourself, well, I didn't ask, so I can write this down. No, you can't. Even if they offer information by themselves without being asked, you can't put this kind of information in your interviewing notes anywhere. You can't enter it in your ATS system. It can't be part of your decision-making process. So basically, you're prohibited, from all those areas that are covered by fair hiring and anti-discrimination laws. Similarly, information derived from social media sites with regard to race, gender, and other protected characteristics should be treated in the same manner. Now, you and I both know that clients are not abiding by this at all, and I speak in front of many talent acquisition professionals, and I'm in front of, corporate audiences constantly telling them why they should use us and why they should hire contractors, and I'm always in front of these audiences, and they will point blank admit to me that the first interview they do is by either Googling a person's name, going to their Facebook page, and they go deeper. They don't only look at the LinkedIn profile, and they don't only Google the person's name. They absolutely go to the friends that they're connected with on Facebook, because they may have settings that protect them from seeing everything on Facebook, but if they can connect with friends of this person often, there's inappropriate information, inappropriate photos, and that's why do we have a responsibility to tell our candidates that they need to clean up their social media image? Yes, we have that responsibility, but we cannot discriminate based on what we've learned from social media sites. And, and I know most recruiters are doing the exact same thing, because you can learn so much more about a person, through social media. And even, very, very legitimate, informative sites like LinkedIn, they still might list some information that they shouldn't have, not knowing, the areas that are covered by the various laws. Now let's address background and reference checks. Under FCRA, staffing firms must give the candidate or employee written notice and a separate document that it may use information from such a report in their employment decision. You must receive written permission to obtain such a report. You have to certify to the Consumer Reporting Agency that you gave written notice, you received written permission, and you will not discriminate against the candidate or your employee or otherwise misuse the information derived from the report as required by federal and state equal employment opportunity laws. And so this is important because our reference checks critical? Yes, they are. They're harder than ever to receive. Most people don't want to give reference checks, but they can sure help you sell in a candidate and give you additional information. But before taking an adverse action based on a consumer report, you must do a couple things. Number one, give a notice that includes a copy of the report on which the firm relied in making the decision, along with a summary of their rights under the FCRA. And when done in advance of any adverse action, the candidate or employee could take action to correct any incorrect information. Because sometimes you're doing background checks, you're doing reference checks, somebody could be angry at somebody could be somebody leaving. There might be a person with a similar name, and you're doing a background check and you're getting information on somebody that is not your candidate. And so that's why you've got to be very careful. If you're checking references, you've got to really verify the fact that the reference you're checking is for the candidate that you represent. Let's go into COBRA continuation and health coverage. Consolidated, Omnibus Budget Reconciliation Act, COBRA, provides for the continuation of group health care to qualified beneficiaries following voluntary or involuntary termination. Qualified beneficiaries must be offered coverage identical to that offered immediately before the qualifying event, and they may be required to pay the premium for continuation of coverage, including the portion paid by the employer prior to the qualifying events, as well as administrative costs. And so, again, when people leave their job, and it doesn't make a difference whether they've left voluntarily or involuntarily, COBRA must be offered regardless of the reason. Let's switch over now to the Immigration Reform and Control Act. And again, I'm trying to give you highlights. The certification exam goes into much more detail on these laws, but for the sake of time and, I just want to hit the key points where if you don't have a lot of training in these laws, I'm at least giving you the important, kind of the critical knowledge points that you need to know on these laws. Immigration Reform and Control Act of 1986 requires that employers only hire individuals who are lawfully authorized to work in the United States. An employee, as defined by, and the acronym for the Immigration Reform and Control Act is IRCA, is an individual who provides services or labor for an employer for wages or other remuneration, and specifically excludes from the definition of properly classified independent contractor. IRCA also prohibits an employer of 3 or more employees from discriminating against any individual on the basis of national origin or citizen status. So as long as they're lawfully authorized to work in the United States, you cannot discriminate based on the fact that they come from another country. If they're lawfully authorized to work in the United States, they're covered under IRCA. Now I want to switch over to I-9 compliance. Employers must complete and maintain the I-9 form for any employee hired to work in the United States. A properly classified independent contractor is excluded. And if you want to know if they're properly classified, there's a lot of question. Does somebody qualify as a 1099 or not? if you've got a question on what is a properly classified independent contractor, all you have to do is go to www.irs.gov, and it'll show you the number of things that must be there in order for a person to qualify as a client, as an independent contractor. And you want to make sure they do, because you don't want them to someday, be told by the IRS that they're not an independent contractor, and they'll come back to you for back taxes. The I-9 form basically has 3 separate sections. The first section is completed by the employee and provides information about themselves, and that includes their Social Security number, their immigration status, and it is completed when the employee begins to work. The second section of the I-9 compliance form is completed by the staffing firm and verifies the identity and employment authorization, and must be completed within 3 business days from the date of hire. So you're seeing that's not 3 business days from the day they start. It's 3 business days from the date of hire, allowing the employee to choose whatever evidence from 3 lists of documents for verification. So they have to give you the documentation. The third part of the I-9 compliance form verifies that the employee remains authorized to work in the United States. I want to go now into the logical next topic, which would be non-immigrant visas. There are 3 non-immigrant visas commonly used with foreign nationals in the United States. It's your H-1B visa, the TN visa, and the B-1 visa. The H-1B visa has been widely used to address reoccurring shortages, to expand the pool of candidates, and to include candidates beyond U.S. citizens and permanent residents. The H-1B visa allows a qualified foreign national who is sponsored by an employer to engage in temporary professional employment in the United States. These visas are typically granted for 3 years, and then they're renewable for 3 years. Employers must file an LCA, a labor condition application, with the U.S. Department of Labor before they can file an H-1B petition. Once the LCA is approved, the H-1B petition is filed with the U.S. Customs and Immigration Service. And so obviously, if you're hiring foreign nationals, you have to abide to the letter by all of these requirements for non-immigration visas. Now, some staffing firms, also use the TN visa. And the TN visa allows certain high-demand professionals to enter and work in the U.S. under NAFTA, the North American Free Trade Agreement. A specific list of high-demand professionals eligible for a TN visa is maintained, and the process for obtaining is shorter and simpler, and no LCA is required. So obviously, the TN visa doesn't have near the red tape as some of the other visas do. While the H-1B and the TN visas are used to employ professionals in the staffing industry on a temporary basis, obviously contractual basis, these are the words that are used, in the laws. That's why I'm referring to temporary versus contract. The TN visa offers a number of significant advantages. The B-1 business visitor visa, limiting types of employment activities, is also used. People entering the U.S. on a B-1 visa are not eligible to work for a client of a staffing firm. And again, you have to know this because it's your job to verify that the contractors that you are representing are legally eligible to work in the United States. Now let's go to federal overtime rules. The Fair Labor Standards Act, FLSA, determines whether a computer employee hired by a staffing firm is entitled to overtime compensations for hours worked over 40 hours. Under FLSA, computer employees are either exempt or non-exempt. Additionally, there's 3 overtime exemptions that exist: executive, administrative, and professional. Now, state overtime laws. An employer must comply with both federal and state laws. The state of California just recently, passed some overtime laws that are crazy, and you've got to pay overtime. I believe it's for anybody that works more than 8 hours in a given day. They don't necessarily have to work a 40-hour work week. So, if in fact your state has, stricter overtime laws than than the federal laws, then you have to comply with both the federal and the state laws. If your business is in one state but you're placing contractors in another state, you have to know the laws of each state. These laws generally apply to the state in which the computer employee is working, not necessarily where your office is located. So when you place in multiple states, you have to know the laws, of those various states and comply by both. Now, independent contractors and waivers. FLSA only applies to employees. Properly classified independent contractors are not covered by the overtime provisions of FLSA. So the Federal Labor Standards Act does not cover properly classified independent contractors. But did you notice those words, properly classified? And again, you've got to make sure they're properly classified. Courts generally have used a 5-factor economic reality test for the purposes of determining where there is an employment relationship between the worker and the staffing firm under FLSA. And so the nice part about these laws is, many of these things have been tried in court. You've got cases that you can basically read, when you're confused about if you're covered, if you're not covered, what happens. There's a lot of things on the books right now in every one of these areas. And so the only law, obviously one of the newer laws, healthcare reform, the interpretation of that law is still up for discussion. But all these other laws, they've got this 5-factor economic reality test that does determine the relationship between, somebody working for you under FLSA. The 5 factors include the following. If it's the degree of control exercised by the recipient of the services, it's the worker's opportunities for profit or loss, and the worker's investment in the worker's business. It's the degree of skill and independent judgment and discretion required to perform the work. It's permanence of the working relationship, and the extent to which the work is an integral part of the staffing firm's business. And so those are your 5 factors. Now let's get into family medical leave. The Family and Medical Leave Act of 1993 applies to employers with 50 or more employees during each working day for 20 or more work weeks in the current or preceding calendar years. Covered employers must provide up to 12 weeks of unpaid family and medical leave in each 12-month period to employees who meet eligibility requirements. Covered employers are obligated to maintain health insurance benefits during the leave period and, under certain circumstances, are required to restore the employee returning from leave to the same or equivalent position. Employees must satisfy 3 criteria. Employed for at least 12 months. They must have worked at least 1,250 hours during the 12-month period preceding the beginning of the requested leave. They must be employed at a work site where 50 or more employees are employed within 75 miles. Now we're going to go over the next law, which is your workman compensation law. And as an owner, workman's comp is one of the most painful discussions that many of us have, because obviously there's great cost factors when it comes to workman's compensation. State workers' compensation laws generally require employers to provide compensation and medical care on a no-fault basis to qualified employees accidentally injured on the job. In return for this protection, the employees generally are prohibited from suing their employer for such injuries. Workman's compensation often is the employee's exclusive remedy for workplace injuries. Most states do not require business entities to provide workman's compensation coverage for properly classified independent contractors. Independent contractors are not prevented by virtue of their status from making claims for work-related injuries against the staffing firm or against the client. And that's important to note because, if they're not classified, if a properly classified independent contractor is not required, you don't pay workman's compensation for this person, then there's nothing preventing this independent contractor, if there is an injury, from suing your client as well as your firm. Let's talk next about employment taxes and independent contractor issues. Many workers providing IT services for staffing firms choose to work as independent contractors. Classification impacts employment taxes and associated employer obligations. While a business entity has a legal obligation to withhold employment taxes of an employee, no such obligation exists for an independent contractor. Should an employee ultimately be deemed to have been improperly classified as an independent contractor by the IRS, the staffing firm may be liable for significant taxes, penalties, and interest. I've seen firms go out of business because their independent contractors were not properly classified. And again, if you want that information, go to www.irs.gov and just type in independent contractor criteria, and you will see what it takes to be a properly classified independent contractor. Because of the subjective nature of the common law test and the inconsistent results it produces, Section 530, enacted by the Revenue Act of 1978, provided safe harbor protection to taxpayers who classified workers as independent contractors. In the Tax Reform Act of 1986, Congress removed the safe harbor protections with respect to staffing firms that provide the services of an engineer, designer, drafter, computer programmer, systems analyst, or other similarly skilled workers engaged in a similar line of work. So basically it covers most, probably all of TSA members. Now I want to discuss co-employment with you. In a staffing arrangement, co-employment simply means that more than one business entity may simultaneously have the responsibilities and the privileges of an employer. Often erroneously ascribed as negative connotation, in reality, co-employment is not always bad, nor is it typically avoidable. Next, I want to address commercial laws and contracts. And I'm sure your head is spinning at this point. We're giving you a lot of information, but this call is being recorded. So if you want to go back and listen to this, and again, I'm giving you a brief overview. These are just the critical knowledge points. We go into much more depth in the study guide for the certification program. The study guide was written by 2 attorneys who really know the employment law and deal with this on a day-to-day basis. And that's why, to give you the information and to write this and provide this information, TSA went to the best experts out there to make sure that this information was, absolutely, correct and can help you in the daily operation of your business and as you daily work your desk. Commercial law and contracts. Contracts between staffing firms and their clients typically address the financial terms and the services to be provided as well as each party's responsibilities. The staffing firm should attempt to limit its liability for risks beyond its responsibilities as a staffing firm. Typically, the staffing firms may assume responsibility for its actions as an employer of its workers, including the obligation to pay wages and benefits, withhold and remit payroll taxes, as well as unemployment and workmen's compensation periods. But you want to specify in the contracts. You want to be very specific to limit your liability. The staffing firm may assume risk for its role in failing to properly screen or qualify an IT or engineering professional that it places on assignment. The staffing firm should attempt to avoid assuming risks related to the client's business, including liability for products, services, workplace, or employees. In this regard, the staffing firm should closely review any indemnification provisions or language which may obligate it to pay the losses of a client under specified circumstances. So basically, you want your contracts to protect you. Client contracts often contain provisions which only allow the terms of the contract to be modified by a document signed by a specifically authorized party. Before signing a contract, a staffing firm representative should understand to what their firm is agreeing and should attempt to negotiate provisions that are unacceptable. And something I want to share with you, because I know I've gone back and forth with this in my own firm. When firms send us their contracts, I have X'd out and initialed several things within a contract and sent it back and had the client say, okay. So don't assume for a minute that if you don't agree to 100% of what is in a client's contract, that they're still not going to do business with you. In fact, we got one contract from a client, and there was so much in it that we could not agree to that I think I crossed out almost half of what was in the contract, and I sent it back. And we had worked with this company before, but they had a new CEO. You know, the C-suite had changed, and so they had new agreements. And I crossed out about half of it and sent it back. And when I got a call from one of their VPs, what they said, you know what's interesting, Barb? We sent this out to the 5 firms we do business with. 4 of them signed it. We don't even think they read it. You crossed out 50%, and the 50% that you crossed out we can live with. Why didn't other people, like, we're kind of surprised that they even agreed. We just tried to get as much as we could, and we're shocked that nobody else made any revisions. Now, obviously, if you're a recruiter and account executive listening to this, this is something you want to discuss with your owner. And I'm sure you've got, you know, a corporate attorney. You've got, you know, and obviously TSA has attorneys as well, you know, that they can refer to you. But, you know, you've got to make sure that you're reading these contracts. You're just not so excited that you landed a client that you just automatically sign a contract. If you're interested in learning more about the laws or learning more about TechServe Alliance, their CPSR, or their CPSAE certification program. CPSR is the certification program for recruiters. CPSAE is the certification program for account executives. And I can tell you, having those letters behind your name give great credibility. You know, when you go to hire experts, when you go to a dentist, they have a DDS. When you go to a doctor, they have an MD. You know, it's good, you know, when you go out there, it just shows that you understand, you know the laws, plus you've passed an examination based on best practices in your profession. And there's no other certification program out there currently that tests best practices. So this is truly, you know, the people that are going through the certification program, I just have to share this with you because I get emails from them and they're like, we are implementing so many of the ideas we learned, Barbara, and I'm a better recruiter. I'm making more money. I'm a better account executive. I'm landing more clients. So the program enhances the base of knowledge, but it also makes all the participants better at their job. And so if you'd like more information, you can get more information by just emailing certification@techservealliance.org, or you can call Susan Donahoe at 703-838-2050. Her extension is 118. And she would be glad to answer any questions that you have. And again, it's one thing to read these laws. It's another thing to really understand the practical application of the law. That's why we have 2 levels of certification. Level 1 is a multiple choice asking questions. Level 2 are case studies, where if you really want to know, if you understand the laws, sign up for the certification program and then take the Level 2 program, because those are case studies. That really almost makes you a little mini attorney looking at something and trying to figure out what law do I apply and what are the answers that are correct here. So, you know, legal is never that exciting. It's never that enjoyable, but it is such a necessity for you to embrace the fact that you have to know these laws if you're going to be great at what you do. It's not enough to be good anymore. You've got to be great. And part of that is knowing the laws that basically, you know, regulate everything that you do as well as your clients and your candidates. It helps protect everybody. So that's the program for today. I don't know if any of you would have any questions. I would almost say that if you've got questions on any of the laws, I would say write them down and take them to your attorney. Now, I do see that I've got some questions down below that I'm going to try to answer. Let's see. Okay, let's see. States may have different ADA laws. Yes, some states, you know, prohibit against any age discrimination. You're right, Peter. And again, it's English. You know, it's. I mean, there's another question here. Poor English speaking skills in the ATS. You can note. Somebody had put down here that you can note poor English speaking skills in the ATS. Again, you got to be careful with those kind of notes, Peter, because that could be discriminating against somebody's national origin if great English is not necessarily part of the job. But you're right. There's state laws that are much more stringent than the federal laws. And if you're in a particular state, you're placing people to work in a particular state, you've got to abide by every one of their laws. And the state that just has been going crazy with laws is in California lately. I mean, it's just amazing what they've done. How do you get the study guide? The way you get the study guide, Brittany, is to sign up for the certification program. The study guide is phenomenal. It's all these laws in depth. It's wonderful. Then it's industry practices. So there's laws, industry practices, and then depending on if you sign up for recruiter or account executive, it's best practices. So once you sign up for the certification program, you can get the study guide. How do you get a copy of this presentation? TechServe Alliance will be posting that. I'm sure they can give you the details. When I'm done answering questions, they can tell you how you can get a copy of this presentation. But they will. They're recording this, and they're going to get this out to all of you. Let's see here. One of our very large clients asked for the entire Social Security number. Is this legal? Well, it depends on what point in time they're asking for it, and why they're asking for it. You have to know the reasons. You just can't arbitrarily, give somebody's Social Security number out, because obviously with identity theft and everything, people are so leery of giving your numbers out. I would ask, what do they need it for? Why are they using it? Now, if they hired somebody direct from you, obviously they need it for payroll, but if they're hiring contractors from you, are they independent contractors? Are they people that are, getting a W-2 at the end of the year? There's a lot of questions I would ask them, and then I would run it by my attorney, find out the reason behind this, and I would check with my corporate attorney and tell them where they're located and what they're asking you to do, and get a legal opinion on that. I don't feel like I'm in a position to answer that, not knowing all the details or the reason why they're asking for it. Okay, how long does it take to take the certification exam? You can basically take the certification exam. You can sign up for it, get the study guide, and if you read the study guide once, you went through it, and then you went back and you read it through slowly, took notes, and really understood it, I would say within 30 to 45 days you could take the certification exam if you put the effort forward. We've had some people that read it once, they take the prep class, and then they take the certification exam, and they do well. But you cannot, there is a prep class, a conference this year. You can't sign up for the prep class and not read the study guide and think you're going to pass the test. Just about everybody that did that, everybody that just thought they could show up at the TSA conference, take the prep class, and then just sit down and take the exam, they did not pass. And so, it does take some effort on your part. Let's see, can you provide clarification on I-9? Currently, we've been viewing them and signing on the consultant start date at our client. Did I understand you correctly? It says to be within 3 days of actual hire date. And if it's later, what if their hire date is the day they sign their contract? According to what the attorneys put in the program, they said within 3 days after the actual hire date, not necessarily the start date. Again, I would ask that question of an attorney, but that's how it's written in the study guide materials, Leslie. And so, I am not an attorney. We always get them signed as soon as possible, as soon as we've got an offer, just to, I'd rather err on the side of being overly cautious than take it to the very end, and then maybe you can't get some of the ID from them, so I try to do it as soon as possible. But I would check with your attorney on that one for added clarification. Or you could, contact the attorneys, at TSA and ask that question, send that into TSA. Okay, those are all the questions that I see. What I want to do now is turn it, oh wait, there's one, let's see. Do you have any certification which will help doing salary negotiations, salary? The certification program for both account executive as well as recruiter talk about negotiating and how to negotiate more effectively. So the two programs that TechServe Alliance does offer, it's best practices. So of course it hits negotiating. Of course it hits, again, the purpose of the TSA certification program was to give you a credential that could help you in bids and help you elevate your base of knowledge. But bottom line, we wanted you all to be more successful and make more money. We wanted the owners that got their people certified to see increased profits. So of course negotiating is a big part of the best practices, because the better you are at negotiating, the higher margins you're going to get and the more profits you're going to enjoy. So yes, that's part of the two current certification exams. Okay, that's all the questions. I do want to turn this over now to, I believe it's Cindy at TSA, to see if you wanted to wrap up, Cindy, and can you also let them know how to get the call?
Thank you, Barb. I hope everyone will join us for the next webinar in the certification webinar series, Why should someone really do business with you? This webinar will be Thursday, September 3rd, 2015 from 12:30 to 1:30 p.m. Eastern Time. This webinar will address how certification is a proven differentiator, why should candidates really send you their resume, why should clients really hire you to find them top talent, and lastly, the competitive edge gained by knowledge retained. Also, we will be doing a certification course at conference this year, so make sure you sign up before advanced registration ends on September 21st. Barb, I would like to say thank you on behalf of TechServe Alliance and everyone attending. Thank you very much, Barb.
You're welcome. Also, and by the way, for this certification prep class, I'm doing it, and I was involved in writing the study guide. So if you want to take advantage of one-on-one training with the person that was involved in writing the study guide, it's great to take the prep class at conference. So I would strongly recommend anybody thinking about that to really strongly consider, taking the prep class at the conference this year.
We will also be sending out an email with today's slide and a link to today's presentation, along with a link to the certification webpage. Thank you, everyone, for attending.
Thanks. Bye.